In his book, The Oath, Jeffrey Toobin provides readers with an in-depth discussion of Justice Sandra Day O'Connor's decision to step down from the Supreme Court due to the fact that her husband John had been suffering from Alzheimer's disease. Over the years, many male members of the court had nursed their wives through illnesses, but few, if any, considered leaving the court to provide that care. Justice O'Connor, however, would do exactly that. During her time on the court, O'Connor was a moderate conservative, and while she tended to side with other conservative justices, she did not help them achieve goals such as overturning Roe v. Wade or ending affirmative action. On June 1, 2005, Justice O'Connor announced her decision to resign from the court. President George W. Bush would nominate Samuel Alito to the Supreme Court. And while we know that Alito faced a fairly rough confirmation process in the Senate, it was he who would go on to succeed Justice O'Connor. It was not long after Justice O'Connor retired that she began to notice that the court began to lean heavily toward a conservative agenda. In fact, Toobin contends that it was as though the new Roberts Court had made a special project of targeting her legacy. For example, in 1992, Justice O'Connor had cast a crucial vote that would save the core of Roe v. Wade. Yet, in the 2007 case, Gonzalez v. Cahart, the court placed new limits on abortion. Had O'Connor been on the court rather than Alito, the decision would have been decided differently. Also, the Citizens United case, which was a 5-4 decision, would have been decided in a different direction had O'Connor been on the court instead of Alito. As you may recall from last week, the recent landmark case, Citizens United versus the Federal Election Commission, overturned decades of campaign finance reforms. It essentially allows corporations to give unlimited support to political candidates by running television ads. Many scholars have commented that this decision greatly benefits Republican candidates, and it should be noted that this 5-4 decision was decided along party lines, with liberal justices voting against and conservative justices voting for. O'Connor has spoken out that she would have voted with the liberal justices in this case had she been on the court at the time this case had been decided. When Justice John Paul Stevens announced that he would be leaving the Supreme Court bench, President Obama began searching for a suitable replacement. The Citizens United case decision reminded the White House just how much harm the Supreme Court could do to them. Obama wanted to place the right justice on the bench while also looking to avoid a big fight in the Senate during the confirmation process. So, keeping that in mind, he would go ahead and he would nominate the person that you see right there, Elena Kagan, the Solicitor General. Kagan began to prepare for the confirmation process and made courtesy calls to senators, which tends to be customary. Interestingly, during these interactions, senators continuously kept asking Kagan about her position on guns. Later, the National Rifle Association would announce its opposition to Kagan becoming the next U.S. Supreme Court Justice. This organization announced that her confirmation would be a scored vote for senators. This meant that if a senator voted to affirm Kagan, the NRA would take note of this. While this might seem rather trivial, many senators, especially Republicans, sought to have a perfect NRA voting record. So this would cost Elena Kagan some votes. The Kagan confirmation, like the Alito confirmation, illustrates just how politicized the process has become. By 2010, it became clear that the days of confirmation with 90-plus votes for anyone was over. Lobbyists such as the NRA made it clear that qualities such as intelligence and integrity no longer mattered in determining who should become a Supreme Court justice. Rather, what mattered more was a nominee's ideology and how this ideology specifically compelled them to interpret the Constitution. Once the legislature passed President Obama's health care law in 2010, the Tea Party came out against this law in full force. The Tea Party is a decentralized movement that is vehemently against taxes and governmental regulation. The Tea Party often refers to the 10th Amendment, which limits states' rights, as well as the Commerce Clause, which limits the scope of federal legislation. Tea Party members are originalists, dedicated to restoring the modern government of the United States to be consistent with the views of the 18th century framers of the U.S. Constitution. Tea Party partisans also insist that the Constitution forbids the regulation of the national economy. They also reject decades of law that call for at least some separation of church and state. Tea Party members viewed Obama's Affordable Health Care Act as a governmental takeover of the health care system. Interestingly, Justice Clarence Thomas's wife, Jenny, is an outspoken member of the Tea Party. She often gives speeches to conservative groups and has lobbied for many years against the Affordable Health Care Act. She was so much an integral part of the Tea Party that 74 members of Congress called upon Thomas to recuse himself from any legal challenges to the health care law. However, the U.S. Supreme Court operates in a peculiar manner. This is because the federal statute governing judicial conflicts of interest cover only lower court judges. Therefore, on the question of recusal, the law is clear that such a decision would be entirely up to the justice, in this case, Justice Thomas. As Toobin suggests in his book, the Supreme Court is one that is very revered, and so I guess the justices have a little bit of leeway. And I think he points out correctly that the attempt to drive Justice Thomas off the affordable health care case was politically motivated. Ironically, and perhaps to Thomas's good fortune, though, the leader of this effort to drive him off the case was none other than Anthony Weiner, who would soon be forced to resign from Congress because of a sex scandal. Regardless of the fact that Clarence Thomas did not recuse himself from deciding the constitutionality of Obamacare, many scholars have commented that Justice Thomas, along with his wife Jenny, have helped to build the infrastructure opposing President Obama's agenda. In many ways, the legal fight over health care reform became a defining symbol of the role reversal that has taken place between liberals and conservatives. Liberals were once regarded as the apostles of judicial activism. However, recently it has been the conservative Supreme Court justices who have begun to engage in this type of behavior. On March 21st, 2010, shortly after the House of Representatives approved the Affordable Health Care Act by a vote of 219 to 212, lawyers in the Obama administration began organizing a defense for this new law. They did this because they knew, without a doubt, this would go before the Supreme Court, which would be the final arbiter of whether or not the Affordable Health Care Act was constitutional. Elena Kagan, who was at the time the Solicitor General, opted out of this meeting. Why did she do this? More than likely, Kagan knew that she would be nominated to serve on the Supreme Court. And if this happened, she did not want to do anything as a Solicitor General that might prevent her from casting a vote in this very important case. Kagan did not want to have to recuse herself. Therefore, she decided not to participate at all, even in the planning of the health care litigation that would eventually be argued before the Supreme Court, probably within a couple of years, which it was. As we know now, it would be Chief Justice John Roberts, and he would be the one who would cast the deciding vote in the case which decided the constitutionality of the Affordable Health Care Act. Before Roberts cast his vote, it was a 4-4 split, with all of the justices voting along party lines. The Citizens United case was decided in a partisan manner and defined the public image of the Roberts Court. Had Roberts voted against the Affordable Health Care Act, critics would have argued that a Republican-dominated court was stripping away the central achievement of a Democratic president. As Chief Justice, Roberts wanted to preserve the court's place as the final arbiter of the nation's disputes. It is highly likely that Roberts voted the way he did because he believed that a complete nullification of the health care law would cause Democrats to crusade against the court, eroding its moral, if not its legal, authority. Tubin contends in his book that the 4 conservative justices on the Supreme Court may have also pushed the Chief Justice into voting to uphold the Affordable Health Care Act. He writes that they overplayed their hand by demanding that Roberts kill off the entire health care law. Roberts, who again wanted to preserve the image of the court, was interested in finding a middle ground if possible. In the end, the Chief Justice sided with the 4 liberal Supreme Court justices, and he assigned himself to write the majority opinion. He argued that the individual mandate aspect of the Affordable Health Care Act does not regulate existing commercial activity. Rather, he argued that it compelled individuals to become active in commerce by purchasing a product on the ground that their failure to do so affects interstate commerce. The Chief Justice endorsed the view that the mandate was a tax, and he therefore voted to affirm the law because he reasoned that the Constitution permits such a tax. Though conservatives swiftly turned on Chief Justice Roberts for affirming the constitutionality of Obamacare, many scholars have actually made arguments that Roberts made a brilliant move that will actually benefit the conservative cause in the long run. For example, Robert Mulchman, a well-regarded attorney and associate professor of law at Cardozo Law School, argues that Roberts helped the individual mandate be seen as a tax under Congress's taxing authority while explicitly rejecting its constitutionality under the Commerce Clause. Mulchman writes that Chief Justice John Roberts assigned himself the majority opinion in order to create the majority view that a health insurance mandate violates the Commerce Clause. This result, in keeping with Roberts' conservative view of restricting federal power, leaves him free to vote to strike down future progressive federal legislation as unauthorized by the Commerce Clause. Moreover, by characterizing the individual mandate as a tax, Roberts hands Republicans a campaign cry that Obamacare means new taxes and that Democrats are the party of taxation. Finally, his decision allows Roberts to falsely paint himself as a neutral arbiter whose principled constitutional interpretations cannot be overridden by his politics. And as Jeffrey Tubin points out in his book, the Chief Justice implies in his majority opinions that he thinks that the law is a bad idea by adding a note at the end of his decision that the court expresses no opinion about the wisdom of this act. And by affirming the constitutionality of the Affordable Health Care Act, the Chief Justice may have also energized the Republican base. In future cases, Roberts will also be free to be as conservative as he wishes without being accused of playing into partisan politics. And while in the short term he may have disappointed conservatives, Chief Justice Roberts' decision to uphold the constitutionality of Obamacare may actually be a long-term victory for Republicans. Of course, only time will tell.